Hi guys, welcome back to our page. Today we'll be discussing a shareholders agreement, the validity of a shareholders agreement, why a shareholders agreement is important, and the requirements for a shareholders agreement. So this video would be of interest to you if you are a shareholder of a company or you have just been appointed as a shareholder. So, a shareholders agreement governs and formalizes the relationship between the shareholders and directors of a company. It is an invaluable document for any business as it provides the foundation for how a company will be run. So, under the previous Companies Act of 1973, which I will refer to as the Old Act in this video, the provisions contained in the Old Act in the shareholders agreement prevailed over the provisions of the Articles of Association and Memorandum of Association of a company, to the extent that any such provisions in the shareholders' agreements did not conflict with legislation. So the Act now provides that any provision of a shareholders' agreement that is inconsistent with the Act or with the company's Memorandum of Incorporation, being the primary constitutional document of a company under the Act, is void to the extent of such inconsistency. And this is in terms of Section 15, subsection 7 of the Act. The provisions of the shareholders' agreements are now subject to the provisions of a company's Memorandum of Incorporation and the new Act, and as a result may no longer be used to vary the provisions contained in a company's primary constitutional document. This fundamental change may well have an adverse impact on the practical utility and value of the shareholders' agreement. So, under both the previous dispensation as well as the current Act, dispensation as well as the current Act, South African law does not prescribe any specific formalities regarding the form and content of shareholders' agreements. But for the limitation, as already mentioned, that the shareholders' agreements may not be in conflict with the company's Memorandum of Incorporation or the provisions of the Act. Shareholders' agreements are contracts between the shareholders of a company and as such are primarily regulated by the principles of South African contracts law. So, as a general principle, contracts need not be reduced to writing and need not, subject to certain exceptions, comply with any formalities in order to be of force and effect. The parties may, however, provide in the contract that their agreements may be reduced to in writing. In such an event, the agreement only becomes binding upon the signature of the contract by all parties to the agreement. While every shareholders' agreement differs, there are several key provisions each shareholders' agreement should have. For example, the board of directors. When it comes to the board of directors, a shareholders' agreement needs to set out the maximum number of directors and the percentage of shares required to appoint a director. It should also contain provisions on when and how a director can be removed, what their duties are, how meetings are called, and how they will vote. That is, will each director have one vote or will they have as many votes as the shareholder who appointed them? So when it comes to the shareholders' economics, the agreement should clearly stipulate the shareholding of the shareholders, the different authorized share classes, if the company has shares other than ordinary shares, the rights attached to each share class, the voting rights of shareholders, and any possible rights awarded or restrictions imposed and tied to specific shareholders. That is, call options, vesting of shares, restraints of trade, and so on. So the issue of new shares, generally the agreements will stipulate that any insurance of new shares is first offered to existing shareholders on a pro rata basis. This is the so-called preemptive rights of shareholders, and business owners should be aware of this rights. Then what happens in sale of shares? The shareholders agreement should also detail how a shareholder can sell his shares or how he can exit. This should be clear in terms of process, notice, timelines, valuation and method. The valuation of shares is extremely important and should be carefully considered. What happens in disputes? Disputes happen and the possibility of opposing views will always be relevant. Where shareholders cannot agree on the running of a company, a deadlock provision resolves this. The agreement should clearly state out how to resolve disputes and what actions can be taken. Minority shareholder protection. A carefully considered shareholders agreement will not only protect majority interests but also that of the minority. The goal is to prepare an agreement which promotes trust and creates shared value. Incorporating terms, for example, that unanimous shareholder approval or the approval of a specific minority shareholder is required for certain company decisions, is also quite common in a shareholders agreement. Anti-dilution protection. You may also want to consider including provisions regulating the raising of capital to avoid diluting existing shareholders. This is especially relevant when you are a significant capital investor. The Memorandum of Incorporation. It is important to remember that the Memorandum of Incorporation is the higher ranking of your shareholders agreement. The Memorandum of Incorporation is, however, a public document, and if there are matters that the shareholders want to govern more privately, this should be included in the shareholders agreement. It is important to note that any matter in the shareholders agreement that conflicts with the Memorandum of Incorporation will be null and void. It is therefore prudent that the two documents be prepared simultaneously. In addition to the terms that I have discussed, your agreement should also reflect the unique culture and purpose of your business. On this basis, if you are getting ready to draft a shareholders agreement for your company or you are reviewing an existing shareholders agreement, it is recommended that you seek legal advice to ensure that your agreement aligns with your business goals, that you understand the consequences of the provisions contained in the agreement. The rationale for executing a shareholders agreement is to provide a means for shareholders to protect their interests in the company and to regulate their relationship with the company and the relationship amongst the shareholders themselves. A shareholders agreement regulates the specific interest provided for by the Act or the company's Memorandum of Incorporation, provided of course that the shareholders agreement does not conflict with any of the provisions of the Act or the company's Memorandum of Incorporation. There are many reasons for shareholders to elect to enter into a shareholders agreement over and above the Memorandum of Incorporation of the company. Most notably, in order is to address and regulate matters which are not dealt with either by the Memorandum of Incorporation or by the Act. Examples of this include matters such as management of the company, the funding of the company, restrictions on the transfer of shares, or voting agreements, in which shareholders undertake to vote in a particular manner under specific circumstances. Shareholders may also elect to enter into shareholder agreements in order to elaborate on the provisions of the company's Memorandum of Incorporation, which is drafted in terms which allows for amplification. Shareholder agreements are not public documents, which means they are not filed with the company's commission and are not open for inspection by the public. The binding power of shareholders agreements stems from contract law as opposed to specific company law legislation, and for shareholders agreements to be valid, they have merely to comply with the general requirements of contract law of South Africa, one of which is naturally that nothing in the agreements contravenes applicable legislation, and also that you need to be competent to enter into such an agreement. So if anything that I have spoken about is unclear, you guys can find a written version of what I've discussed today on our website, that is www.lawfirm.co.za. www.lawyerseasyfine.co.za. Please do click on the like button and subscribe to our YouTube channel. Also click on the bell button to get post notifications, and do stay tuned for our next video.